May it please the court, counsel. I'm Paul Lundberg. I represent Rosauer Corporation in this appeal. There are two interrelated questions that the court needs to decide in this appeal. First, whether the judicially created doctrine of implied warranty of good workmanship should be extended to subsequent purchasers of developed residential building lots where no structure has been erected. And secondly, whether this is the proper case in which to extend the doctrine. As the law stands now, subsequent purchasers of developed residential building lots that contain latent defects under the soil caused by poor workmanship have no remedy against the developer. Spate, or the Spate case on its facts, was limited to residential structures, and this court's interpretation of the economic loss doctrine precludes any claim in negligence against the developer by a subsequent purchaser. The plaintiff in Spate was a subsequent purchaser of this house. Well, that plaintiff was also a subsequent purchaser of the lot on which that house stood. If the defects in the Spate house were caused not by poor construction practices by the contractor, but rather by defectively filled and compacted soil under the lot, the holding in Spate would say you can go back to that original builder vendor, but you can't go back to the developer of the lot.
Counsel, should we look at the reasons why the implied warranty was created by the court in the first place to see if those reasons support extending it to your situation?
I believe that's entirely proper, Your Honor. And the Spate court was concerned about latent defects that may not be discoverable by reasonable inspection. And it said, by definition, latent defects can't be discovered by reasonable inspection. You can't go in and walk around the house and determine whether there may be a structural defect. The same is true of these residential building lots. There's no statute that says purchasers or subsequent purchasers have a right to conduct soil testing before they buy the lot.
Well, but then you just don't buy the lot. I mean, you say, well, I want to do a soil test before I spend a lot of money. It seems to me, arguably at least, inspecting developed land is less burdensome and less troublesome than inspecting a house that might be full of latent defects. Particularly, in one case, your home buyer has limited ability to do that. In purchasing lots for development, you might be a contractor, you might be a business person, you might be somewhat more sophisticated. So I'm concerned that some of the public policies behind Spate might not be as strong in this case. So help me on those points. All
right, Your Honor. Well, the only way to discover the latent defects in the lot is by invasive soil testing. Mr. Rosauer testified that after this lot, and he built a duplex on it, he bought 2 or 3 more lots, and was refused by all the owners to do pre-purchase soil testing. He had to negotiate with them to say, well, I'm going to test afterwards, and if it's faulty, I want my money back. Mr. Rosauer was operating here under the, I think, reasonable assumption, and of course we were at the summary judgment stage below, so the facts that I'm relating are taken in the light most favorable to Rosauer. But he said, I paid $50,000 for a 1/4 acre of what used to be farmland, has now been platted and filed with the city of Sioux City as a residential subdivision. There's an architectural review committee that is going to review your plans. There are restrictive covenants. Hasn't Mr. Sapp impliedly warranted the suitability of this property for residential construction without further investigation. And I think, one of the elements of the implied warranty claim is that the purchaser be unaware of the defect and have no reasonable means to discover it.
But isn't just doing soil boring tests a reasonable means to discover whether the soil is suitable to build on?
It is the inspection of choice. It is. But the concern is, will all purchasers have that ability?
But can't the law expect developers to look out for themselves? After all, your client, when it bought the later lots, negotiated and received express warranties. Why couldn't it have done that with the first lots it bought?
Perhaps it could. And perhaps all home purchasers who have statutory protections in terms of a seller disclosure statement, the right to pre-purchase inspection, perhaps they need to write into their deals an escape clause should latent defects develop. But that, I guess what I'm saying is I don't think that's necessarily the real world, and what we have are...
In this case, before your client purchased the first lots, did it learn that there were settlement problems with other buildings in the same development?
He had heard rumors.
Did the rumors put it on inquiry notice that maybe before it took the plunge, it ought to do its own testing?
Very possibly. What Mr. Rosauer said was, those were all down by the golf course. We're up here on the hill. I didn't think there was going to be a problem. And again, if he was buying... if all Sapp Development did was divide up this farmland and say we've got half acres for sale or quarter acres for sale, then you're on your own. What we're advocating is the same thing that happened in Spite, and that is some protection for latent defects caused by poor workmanship, not by the inherent characteristics of the land.
But Spite, the plaintiff was a homeowner living in a structure, and here we don't have anything built on the land. What's the state of the law nationwide on recognizing or extending the tort of implied warranty of good workmanship to just land, whether it's been backfilled or not?
There are jurisdictions who say no. There are at least 4 jurisdictions identified by the Court of Appeals in its decision that say there is an implied warranty for improved or developed land. The North Carolina case, I think it was Hinson versus Jefferson, held that by imposing restrictive covenants on these residential lots, the developer is impliedly warranting that they're suitable for residential construction. And, if there hadn't been any rumors in Whispering Creek, would it have been reasonable for any purchaser to say, well, I know, they're saying they're buildable, but, do I need to find out? I think it's unreasonable to expect.
But I'm still troubled that this case doesn't involve a claim by a homeowner living in defective housing, whether the defect is the way the structure was built or because of a problem with settlement with the underlying land. Why should we extend this implied warranty to a developer in the business for profit rather than someone living in it?
Well, I guess my response would be because many of these subsequent purchasers of these residential lots will also be buying a house that's sitting on it. The extension of the doctrine, as I suggested in the opening of my argument, would also cover people like the plaintiff in Spite. If his structural problems in his house are related to latent defects in the land, he may not have a remedy against his builder vendor.
But can't we address that case if we come to it? That's a little bit different situation where a homeowner buys a home and then it turns out the the foundation sinks because there's improper compaction. I mean, here we have a developer, a realtor, and a developer. Three kind of sophisticated parties that traditionally we make them look out for themselves, don't we?
Yeah, yes, and again, I think the facts here in the summary judgment record are that Rosauer Corporation, at the time he purchased this lot, was a commercial entity, but he was not a sophisticated developer. This was the first lot he ever bought. This was the first house he ever built. Sure, he bought a couple subsequent to that. But in looking at Rosauer and whether he's the type of person that deserves protection, again, I think that goes to the element of the implied warranty claim that says, does this purchaser have any reasonable ability to discover the defect? And I think that's a factual inquiry for the jury, if there's a cause of action.
Was there anything that prevented him from discovering the defect? I mean, when the time came to do the soil boring, there it was discovered.
There's, not that I know of, there's nothing in the record as to whether Sapp Development, either for initial purchasers or subsequent purchasers, was, I guess Rosauer bought this from Mr. Bailu, whether he could have bargained with Mr. Bailu for soil testing. I think that's possible. And again, I think that goes to whether, with regard to the factual elements of the claim, whether he could have protected himself or discovered the defect using reasonable care.
So the doctrine, would you agree, originated with the implied warranty of habitability? We wanted people not to be living in conditions of squalor. We wanted them to be living in good conditions. How would that rationale apply to a lot that doesn't have a building to live in on it?
Well, I think the evidence in this case shows that these problems with placing fill and compaction can be widespread. And if we're looking to kill more than one bird with a pronouncement, in Whispering Creek alone, Mr. Sapp was involved with about a half a dozen other claims, exactly the same. The fill was not placed in the proper lifts, it was not compacted properly, and yet all these lots are held out as suitable for residential construction, and you have to comply with their architectural review, and you have to comply with the restrictive covenants, and anyone purchasing them has to reasonably assume they're ready. And so the doctrine as announced in spite was implied warranty of good workmanship or fitness for the intended purpose. And whether you look at either one here, I think it was not fit for its intended purpose. Mr. Sapp knew that you must do this correctly to have buildable lots. He talked to an engineer. He put specifications in his contract with the grading company. This has to be done correctly. And if it's not, they're not buildable. And if they're not buildable the way the law stands now, the subsequent purchasers do not have a remedy.
Would you agree that if there is an implied warranty, it could be disclaimed? For example, that that Sapp could have said something to the realtor like, we're not warranting the soil compaction is suitable for building, do your own independent tests. Would that protect Sapp if they had done that from a claim by your client?
I believe so. And Sapp did file a fill addendum with the plat, purportedly to show where there's more than 5 feet of fill on any of the properties in Royal Highlands 3rd Edition. It doesn't warrant that it's done correctly or anything else. They just put you on notice. You might have more than 5 feet. The soil testing people that looked at Rosauer's lot said, well, the fill here is undocumented. We have 15 to 18 feet of fill that's undocumented, and not properly compacted. So it is Rosauer's position that the court should recognize and extend the implied warranty doctrine to cover this situation, reverse the Court of Appeals decision, and remand this case to the district court for further proceedings. Thank you.
Thank you, Mr. Lundberg. Mr. Seeley.
Please, the court. Mr. Lundberg. I had the opportunity to sit and listen to the first two arguments, which dealt with statutes. This is a different case entirely. We don't look at statute. This is created by this court. The implied warranty of habitability, of workmanship or habitability was created in Kirk. And so the question becomes, for this court, how far do we want to extend this? And is this the case that we want to continue to extend this theory and the policy that was behind Kirk and the cases that came later, do they apply in this factual situation? I think the facts are critically important, and those facts can be seen in Tony Rosauer's and Todd Sapp's depositions about what was going on this particular piece of property and why this case is not the case for the court to extend implied warranty. Todd Sapp lived out in Whispering Creek. Whispering Creek is a large development in Sioux City, hundreds of homes, large acres, many acres of land. Todd Sapp lived right across the street from this condominium duplex that was being built. There is no evidence in the record that that piece of land had any problems whatsoever. CTS, who did the borings on this, was the exact same company hired by WC Development to do this entire project. So the expert, if you will, in the Kirk series of cases, there's this discussion about well, we got to protect the consumer because houses are so complex, you would have to go out and hire an army of experts, and even then you still may not be able to find the problem because houses have become so complex over the years. That's not this case. The very company that did the soil borings, as soon as they were contacted, came out, the very first test, discovered the issue that brings us here today. There's this concept of latent, and I don't know how you want to define latent, but in my mind, the issue of a latent defect goes back to these homes where you hire the army of experts and you still can't find the problem. That's not this case. Yes, it's under the soil, so your first reaction is, how more latent can you be? In my mind, latent means you can't easily discover it. This was discovered immediately upon CTS, the entity that did the project. They came out and discovered it immediately. Todd Sapp, go back to the facts of this case and why it's not appropriate. Todd Sapp testified that we have in our covenants, on page 13 of his testimony, we have in our covenants, soil testing is your responsibility. It's in the covenants to the whole entire development. WC Development's not responsible for the soil testing. And he said the reason for that is because CTS told him when they were doing this project, we cannot warrant every single inch of this tremendous development for every single parcel. We just can't do it. And so they put it in the covenants. It's on you for the purchaser. Then going back to more of the case, there's this issue that this happened on 2, 3, 6 other lots. I think that's irrelevant to this because we could get into the facts of each of those cases, and I don't think that that's what we want to do. But what the court needs to understand is what I've said earlier, and that is 2, 3, 6 homes having issues, I don't think is unusual at all when you consider there are hundreds of houses out at this development. And so that's what distinguishes this case from, I think Mr. Lundberg had made reference to other cases in other states that had come to the conclusion, well, we're going to extend it in that case. You'll have to read those cases closely because, I mean, for example, the very one cited by Mr. Lundberg, I think it was the Henson case. It was a septic tank case. In the Henson case, the court said the land was utterly without value, valueless. And so that's not the situation that we have here. So you have to look at those cases particularly, but this is a very large area, and that's exactly why Mr. Sapp and WC Development put it in the covenants. Then going into the particulars of Mr. Rosauer, and I hope I'm saying his name correctly, this is not Anthony Rosauer and his family purchasing a home. The pleading of this case is Rosauer Corporation. And what was this corporation? In his deposition, this corporation was a home builder. It had two elements to it. One, we build homes, and two, we do earthwork. We do landscaping. And he, in fact, was the gentleman who did all of the remediation for this. So he knew what he was doing. He's very intimately knowledgeable about this area. In his, going back to the factual situation again, he said in his deposition on page 41 that before he purchased the lot, he knew he was going to soil test. He knew he was. And he bought the house, and then he deliberately had decided that he was going to do it after closing. Again, I can't imagine this is the vehicle that this court wants to use to extend implied warranty to say, for an individual who knows he's going to soil test, and that soil test immediately discovers the problem at issue, and you chose not to do it, and we're going to say this judicially created law of implied warranty, which is a good law, we're going to extend it to that situation. Mr. Lundberg said he wasn't a sophisticated person. Again, he employed 30 people at one time. Rosauer Corporation employed 30 people. Again, the concept of him being unsophisticated, he bought this lot through being, it floated to him. The Ken Buyu, the real estate agent here, didn't make him pay for it up front because he knew he was a land developer. He was speculating. Mr. Buyu himself had speculated on this land. He bought it for an investment purpose. He then turns around and sells it to Mr. Rosauer for the exact same reason, speculation. And he wasn't going to make him pay up front. He was going to float him the loan until after he built it. Then he was going to then require him to pay for it after he made money off of selling it to somebody else. He had purchased, I think, 3 lots altogether, maybe 4. So this is, in this situation, I think it doesn't apply, and it's not where the court wants to extend. But I think the analysis is the same analysis that both the district court did and the Court of Appeals did, and that is you take Kirk and you take those elements in Kirk and you try to put the policy reasons behind Kirk and you apply the facts of this case or any other case that comes down the road, and let's apply the policy the rationale that's behind those cases, and let's see if it fits. And I think that immediately once you do that, like both the lower courts did, you end up saying to yourself, it just doesn't fit. There are three principal reasons that I see that run throughout, not just this court's analysis in Kirk and in Spate, but in all of the cases across the country that look at this. And the 3 policy rationales are home construction techniques have changed, and I think that's in reference to the fact that when people used to buy a new home, they wouldn't build it. Housing development has developed over the years to where you actually are building the house yourself, and it used to not be that way, or if it did, you would be the one going out and hiring your own general contractor. In this day and age, that's not necessarily true. Second, increasing interest on consumer protection, and third, the complexity of houses. I've covered a great deal of those, but going back and looking at the first element of Kirk, is the house was constructed to be occupied as a home. House is the critical analysis because it's a house as it is now constructed. And you can look at it and you can see this is how it is now constructed. With a lot, you have no idea what is going to be going onto that lot. You don't know if it's going to be an 1,800-foot square ranch, or if it's going to be a 8,000 square foot home with an indoor pool with garages underneath the land. You have no idea if you need to go down 8 feet for the foundation, or if you need to go down 18 feet because this thing is a mammoth McMansion. You don't know what you're doing at that point in time. So that's the difference here. Is this was not a house that one could look at and say this house wasn't properly constructed. And in Kirk, the court said that it's important to look at the primary purpose of the house was a house. The court also said the house is important because of the concept that I've talked about before, and that's latent defects. Here, no latent defects because it was easily discovered. Going on, the second element in the Kirk analysis was the house was purchased from a builder, vendor, and was constructed for the purpose of sale. Again, I mean, I don't need to belabor the point because it's very clear with that second prong of the test, it just doesn't fit in this type of situation. And I think these other cases from across the country that have said, we're looking at the policy rationales and the policy rationales don't apply in our same situation are very interesting. The Cook case from Oregon, it said that the reason for implied warranties were to protect the consumer and an acknowledgement that buyers of houses, like buyers of other goods, must of necessity rely on the expertise of the builder or the manufacturer. Cook came back and said that just doesn't apply to land that doesn't have a dwelling on it. Cook found that there is no general expectation in the public on the part of purchasers that the land will be free of all defects. And I don't think it's probably appropriate, so I apologize, but I'm a perfect example of it anecdotally. Way back when I was much, much younger, bought a house, and when I bought that house, I bought a lot. Before I bought the lot, I had it tested. I had the soil tested. I think that's what most people expect to do when they buy a lot. The third prong or the third element of Kirk is when sold, the house was not reasonably fit for its intended purpose or had not been constructed in a good workmanlike manner. What I want to focus on there is the intended purpose. The courts looking at this have, I thought, done a very good job in saying, when you have an open lot, what is its intended purpose? Certainly to put something on it at some point in time, but what?
If you have it zoned, if you've satisfied all the if it's within the city limits at least, and you've satisfied zoning regulations and it's residential, you have a pretty good idea what it's going to be used for.
Yeah, you know it's going to be a house. I don't disagree with that at all, but one of the things in the case in trying to find it, I think it was a South Carolina case that said that that basically, because of architectural plans vary so much, and maybe I'll find it here before I'm done, you just don't know. A person who's selling lots just can't warrant the wide disparity in what type of homes and structures are going to build. It just would be impossible to saddle them with that burden. And the question was asked, well, couldn't you put in some type of writing that says you're not responsible for it? That was done. That's in the covenants.
The record?
Yeah, it's the covenants.
It's not in the appendix, I don't think.
Well, it's described in Mr. Sapp's deposition, and I can give you the exact page number. Sapp, page 23, he talks about the covenants that run with the land, and in there it was to do soil testing. So then the fourth element was at the time of the purchase, the buyer was unaware of the defect and had no reasonable means of discovering it. We've touched upon that as it relates to I just don't think that applies here because the soil testing discovered it right away, immediately. I think it would be a different situation that we'd be faced with if that wasn't the case. So I think that this court should affirm, the Court of Appeals should affirm the district court and not create and extend this implied warranty well beyond the policy rationales for why it was ever developed in the first place. Thank you.
Thank you as well, Mr. Seeley. Mr. Lundberg, rebuttal argument.
Thank you, Your Honor. Following up on Justice Mansfield's point, I believe Mr. Sapp's deposition is in the record. His reference to restrictive covenants is in the record. There is no, in this record, the restrictive covenants aren't in the record. There's no evidence as to what they say about soil testing or not soil testing. And so I think it's likely inappropriate to rely on those. As I understand Mr. Seeley's argument, if Mr. Rosauer had been buying this lot to build his own house on, then it might be the proper case to extend the doctrine, but because he's going to buy the lot and build a house or a duplex to sell to others, it's not an appropriate case. Seems to me that that would be an overly restrictive extension of the doctrine to say you have to be buying this lot and you have to keep it and you have to build your own house on it and you have to live in it. I don't think that's an appropriate way to extend the doctrine. It goes back.
Counsel, some of the cases that recognize the doctrine to protect homeowners speak of the disparity in bargaining power. When they're, where is there a disparity in bargaining power here?
Between Mr. Bailu and Mr. Rosauer, probably there isn't any. All we can do, or what a jury would do, is try to say, did Mr. Rosauer have reasonable means to discover this defect before he purchased it? And what's the evidence going to be on that? Well, there isn't a lot of it in the summary judgment record because it wasn't pertinent to, the summary judgment was filed on the ground that we had no remedy, no negligence.
Let me ask you this, though. A soil test, very common, doesn't disrupt the property much. You know, when you're in a home, you're wondering about the electrical. You could tear up the drywall and look at the electrical, or you're wondering about plumbing, or wondering about, central heating, and it's all covered up with whatever. So, it seems to me that this getting a core sample is common, simple, easy, and doesn't undermine the integrity of the lot at all. Looking around some house to figure out whether all these defects occur strikes me as more of a challenge.
Understand, and so what we would need is a bright line rule to say, unless you get soil testing done, you have no remedy. And I don't think that's the current state of the Iowa law. On residential subdivisions, not raw land, not farmland, not commercial development sites, but residential subdivisions where poor workmanship has been applied. Not just dividing them up and selling them, poor workmanship, just like poor workmanship in spite. I would agree totally that a residential building lot that's been filled and compacted sitting there is not as complex a structure or entity as a home. But the same principles would seem to apply. Just a couple of things that Mr. Seeley said. Well, these other claims that Mr. Sapp had out there, those are really kind of irrelevant. I don't think it is to the policy considerations here that you're looking at situations where the damage isn't confined to one home. There can be widespread damage. The builder vendors, they're subject to liability. The subcontractors in home building are subject to liability. Why should the residential developers who apply poor workmanship to these lots be given a free pass? And why, in this particular instance, should more focus be on who the plaintiff is than in the other cases? You know, Spite said, well, most of these homeowners are unsophisticated, but a lot of them aren't. Architects buy homes, engineers buy homes. They have the protection of the Spite holding just as much as unsophisticated owners do. And the same thing should apply here. Tony Rosauer had 30 employees who put bushes in and retaining walls. The evidence is undisputed. This is the first lot he ever bought. This is the first residential structure he ever built. And on those facts, I think this is the proper case to consider extension of the doctrine. Thank you.
Thank you as well, counsel. The case is then submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.